don't know if you got it, just to say that they can't make it this morning, or he can't make it. Bradbury is away and he'll be here next week, so he said he'll come next week if we have the meeting next week. And maybe what I want to suggest is that we can talk about what was given to us last week by Stephen Long, but I'd prefer if both parties were together, and so that at least if there's any agreement or way forward or resolutions, we can all discuss it and have a way forward.
When did they cancel?
They cancelled, well, Steve Long sent me the email this morning to say that he can't be here.
That's a bit rude, isn't it?
And Bradbury cancelled last week. He was saying that he couldn't make it today. And then Stephen Long was going to come. I said, we go ahead. Well, so you asked for the meeting. And then basically I got an email from Steve Long so that Bradbury's out. He's only here next week. If we want to meet, we can meet next week.
I don't particularly need to meet with him unless we have to, as long as, because it's basically at the end of the day, it's just a plan.
As a person who came in late, I just understand there's one set of plans that we all signed, and which is now incorporated in the title deeds. Mm-hmm. There's a second set which the council signed, probably in error from what I understand, but you can comment on that.
Yeah.
And then there's a third set, or there isn't a third set, but they're building to something different for both the others.
Okay, that third set we don't have. The building to other plans we've stopped. Steve has been stopped them in doing that. They've come to us and they said that they are going to be building in accordance with an approved plan, and that's all we allow them to do.
The plan we were being presented was the upper floor, drawing 103 revision 4, dated the 12th of October 2011. Aussie refers to an approved drawing, which is to the left, marked yellow box A09, and the drawing we were being presented is to the right, marked yellow box B11. It was very confusing because on the A09 plan, the approved plan, the upper floor was marked deck, and on the new plan drawings we are being presented in 2011, it stated patio.
Oh, here we are. So this is the upper floor plan.
This is new proposal.
Yeah.
Yep.
And that's a patio and a planter.
If the sign drawings didn't have that kink, he wouldn't have got the permission, the support of the neighbours, because we all know that the floor with the little glass balustrade becomes the
Trafficable area.
the veranda at the end of the day. So we would have asked him to take that back to 6 metres to make sure there could be no
What is this
funicular
now?
later.
And
now
also,
that we know that funicular is their second name, of course.
4.7.
but also it wasn't flat like this, Aussie. There was a
1.5.
lip. There was a lip before. Okay,
So what
now
is
it's
he proposing?
flat.
You want to put a planter?
On that level, he's putting a planter in that space.
I really don't know.
If this is a decent guy you're dealing with, we'd be happy with
6 meters
every
and there's a
indication
planter in that
he's not
space.
interested in rules and regulations, He just does what he wants.
And this also had a lip. It wasn't flat. Why has he flattened it? He wants to walk on it.
It's that thing that stands proud. Is that what you're on about?
Yeah, it was all the way along the side of the building, and now it's just flat on the balcony.
That's what I spoke to you about.
Yeah.
You said you can get a projection.
Over up to
Yes.
meters. It's an eave, basically.
Are you allowed to do that?
You're allowed eaves.
An eave is a portion of a roof projecting beyond the face of a building, including any gutters. These aren't eaves. These are reinforced concrete awnings, and they were supposed to be demolished. They were demolished at one point, but rebuilt again without planning approval. But the eave should be down like that. It should be down like
But
that.
it's set back. The building is set back. The eave, it's just protruding. So
He's
it could
going
be
to
argued
use
that
that
it's
to
a-
You think he's going to walk along there? So where's he
Absolutely
going to
no
walk to?
doubt.
How can he?
Where's he going to go to?
Because he can walk forward.
Before it was stepped down.
It was a step down. Now
it's at the
it's
same
flat.
level as it's at the
Yeah.
the level
All along the front of the building?
Yes.
Where would he want to go to?
But it's got 1.5 metres to walk on.
He's got 1.5 metres to walk on, exactly.
That's a deck, and it's illegal.
That affects you.
It affects me totally. Even just the builders leaning on the thing, you
So
know what's
the
going to
proof
happen.
plan, what does it say about that?
It says it's
There
there.
wasn't a lip on it.
Not on there.
It didn't have a lip. No.
Didn't have
Just
a-
ask to take it off. I think, Chrissy, what you've got to decide is either you go for the guy on the original plan that we signed,
Yeah.
and that's what I said in the meeting this morning, or take this plan we got here which council are legally bound to work on, is that
Yes.
correct?
That's right.
And go back and say, listen, there's no lip, remove the lip, finished.
But that's what I would like.
Yeah, and
That's the lip. No.
But can you walk on there, or is it just a...
Well, it's 1.5 metres
Yes.
One and a
of
half.
roof
Yes.
for the
it's
ground
huge.
floor.
saying the downstairs is 4.5 metres setback, right?
Yeah.
And there's a roof on top
Yes.
of that.
Yeah.
The top setback 6 metres. So the planter he's putting in that 1.5
There's a
metres.
roof.
That's what we're talking about.
That's it.
But now hold on a minute, now what's that?
That's the
What's
roof.
that line over there? But this has got, where's, okay, northeast, so where's the west, southwest elevation? Western elevation. Okay, so he's got sliding doors that go out there. So that shouldn't have been approved because he can get onto that. That would be an overlooking feature. He's
Yeah.
got doors going onto it.
What is all this glass here? Oh, that's the top there, yeah?
Yeah.
But that's
So
what
that
the
should be
surveyor
set back
said.
1.5 metres, shouldn't it? That glass, legally.
Oh wait, sorry. I'm sorry, Ozzy. That glass over there, X seems to come out onto this balcony.
That's
And
what
there's
my surveyor
nothing
said.
blocking this balcony. So that balcony is an overlooking feature.
Yeah, that's exactly what the surveyor
At
said.
first floor level.
That's where they're putting the plant.
Planter to set it back.
No, no,
We
no,
don't want that.
All the way
So,
up.
yeah,
Yeah.
but you can't get to it.
No, I
The
think you
doors,
can.
okay, let's have a look.
Let's
Yeah, that's the window. And there's a door that opens up there, and
We're going to walk
That's
on
Which
fine.
that.
means you can get onto that.
Yep.
That leaves us 1.5 metres of the downstairs roof.
Look, the issue here
That's not
is
right.
you are still exercising your options in terms of exhausting your, what's the word? Exhausting your alternatives before you apply to a court.
Yep.
But I mean, these plans,
But these aren't even legal for council.
well, that's what we're saying.
Yeah.
The proposal
Okay,
Don't
so
need
we
to
deal
go
with
to
that.
cannot be
What
approved.
what if we don't accept this? We say we're not interested. What then? I'm saying you guys.
oh, we're sticking to this plan.
Yeah.
This is what we're going with.
These are the approved plans that Aussie Consolvis was referring to. Scenic Drive Approval Drawings 101 plans and 102 elevations, with an application number 183068 signed by Juliet Leslie and Sandra Hustwick. I won't go into the drawing fraud here in this video, but basically Aussie Consolvis, Fiona Ogle and Antoinette Markram obstructed coloured drawings from me until August 2014. The drawing that would ultimately be approved in July 2012 was dated 16th of the 4th, 2012. Drawing 103, and you'll note there are no revision numbers, and it is titled Upper Floor Rider Plan. It was exactly like the one we were presented in November 2011. Nothing had changed. The whole negotiation process was a sham. In fact, it was a fraud. Despite the City of Cape Town pleading under oath, all building works were lawful and were a party to Honourable Judge Bozalak's court order, 13 years later, ex-DA Mayor Ian Neilson and Mayor Heel Lewis now have the power to give retrospective planning approval on the very same structures that were illegal in 2011 and at Honourable Judge Bozalak's site inspection in May 2016. The South African Council for the Architectural Profession found the architect Stephen Long guilty of fraud. He was fined 25,000 rands. Yet the city have only fined the owner, who is responsible, 500 rands. How does that deter illegal building? Part of this tribunal pack was an email from Stuart Bradbury to the prosecutor Bessie Schloppe. He accused me and Chris Willemser of the Camps Bay ratepayers of bribery. I stated my case and I sent this letter to Chris Willemser to ask, did he try and bribe? Is it true? Chris Willemser refuses to answer, and I need to know. So, he must answer. This is a serious accusation. On the 2nd of October 2023, Chris Willemser wrote to Juliet Leslie, and he basically said that the application was fraudulent, the owner is aware of his obligations, about the agreement, but he never even bothered to turn up at the PAAP. He didn't even make any submissions. Then, out of the blue, on the 1st of July 2024, I had an automatic reply from Juliet Leslie. Good day, I have retired from the city. Juliet Leslie is instrumental in this fraud. Juliet Leslie must answer.
Just for the record, I'll note that we are dealing with the matter of an application for permanent departures in terms of the municipal planning bylaw for Earth 58 Camps Bay, number 12 Victoria Road, Buckworthing. And we are here dealing with the appeals on this matter. I have here that from the applicant we have Mr. Carl Hofmeyer, Jody Francis, and the applicant David Bradbury.
Chairman, Mr. Bradbury is unfortunately aboard, but I'm accompanied by my candidate attorney, Mr. Lonnie Butter.
Right, thank you very much. And for the appellant's side, the names of Ms. Christine Phillips and Mr. Barry Varkel.
That's correct, yes.
Sorry, and the other gentleman is?
Mr. Desmond Retief.
Oh, Mr. Retief, the applicant. Thank you very much. Sorry, the appellant. Right, so the process I think has been explained to you. We give each party 10 minutes to state their case. After that, then each will have an opportunity of 2 minutes to respond to each other. And we request the appellants to go first on that. So I don't know from the appellant side who is going to proceed.
I naively assumed we were going to have 10 minutes each. I have WeTransferred. I didn't know what information was. I got an email saying I must send information, which I had no idea what that meant. And I wrote many emails requesting what does information mean. So I was under the impression I had 10 minutes and Mr. Varkel and Mr. Retief had 10 minutes. So this is news to me.
Well, if
that
we
we've
do
only
that,
got 10 minutes.
If we do so, then we've got to give them 20 minutes.
They can have as long as they want. I don't mind. I've prepared a PDF because I had no agenda. Excuse me, sir. I had no agenda, no minutes. I've got no idea who all these people are.
Well, that's
Mr.
why,
Van der Merwe, I've met you before. Hello.
Well, that's why I've introduced. So I complete my introductions.
Okay.
The panel is sitting up here. The 5 members of the panel, all our city councillors appointed by the mayor. And sitting at the back, we have members of the planning department.
Chairperson Ian Neilson did not give the names of the 2 males from PBDM sitting at seats 11 and 12. I asked specifically in writing for their names, and to this day they refuse to tell me who they are. Why? They work for us. We pay their salaries. Why can we not know who they are?
And also assisting in the panel is the panel's own legal advisor and town planner, who are separate from the department.
Sorry, Anton?
Who are separate. I haven't given their names.
Oh, sorry.
I'm just stating their position.
Again, we weren't given the names of the female and male attorney and town planner. They're assisting the panel. Does that mean they work for the city, or does that mean they work for the Western Cape government, or do they work for national government? I've got no idea. Once more, I have been refused the names, despite my email request, of the female sitting at 16 and the male sitting at 17.
Okay. Right, so...
Excuse me, sir, before
Yes.
you... I've prepared a PDF, and I just want to make sure that you've all got it, because I'm going to be reading from it, and you'll need to refer to it.
Okay, so let me say also that we have all the documents. The panel has all the documents from this case, both the original report that went to the MPT, the MPT's decision, all the attachments, all the appeal documents, the panel's had all of those and has had the time to read through those, and we've also had an overall presentation from the planning department on the issues in this case.
Now, this was prejudicial to me because they had a meeting with the planning officials, and I had no idea a town planner was going to be there from the panel. If I knew that, I would have brought my own town planner. Why could we not hear the discussions between the PBDM and the panel? Why, if there's nothing to hide? Why can we not ask questions? This is not fair.
But if you have a PDF that you want to hand out,
We transferred it as I was requested. I was requested to send information. I had an email on Sunday night at about 8:20. So I then, because I didn't know how, I've never been to.
No, well, it's up to you how you present
well,
yourself.
I've given it on a weed transfer. It'll be much easier for you to refer to it as I'm going through it. It's 72 pages. And
Okay, is that on the screen there?
oh, perfect.
Right. Okay.
Brilliant. Thank you so much.
Right. So
I mean, I don't know whether I need to read.
it's up to
The
you
whole
how
thing-
you present. We don't
or-
tell you how to. You must make your own presentation as you wish. You're
Okay.
free to do so, but you have 10 minutes.
Okay.
Please, and if I can request that we recognise that this planning appeals panel has limited authority, is only dealing with the application in front of us. There's no other matter that we can deal with here. So my request to the parties is to confine themselves to the applications for these departures.
Which means the balustrade, the wind lobby, and the satellite
Correct.
dish. That's what I've done,
Thank
sir.
So please proceed.
Thank you. Okay, so basically I sent photographs of the glare in my Annex here 2, which was sent on the 3rd of July 2024. I've just put the Brighton Township Title Deed Clause H, which I don't need to read unless you want me to read it. And then the photographs below are marked yellow box A and B, and you will see that this was taken on the 7th of March 2012, where you'll see Mr. Stern and Chris Willemser from the Camps Bay Rates Association standing on what is a ground floor roof. So after some deliberations, it was then decided that Mr. Bradbury was going to move that west-facing wall and use the ground floor roof. So when I just say a ground floor roof, that's what I'm discussing. So on the 4th of November 2014, I met with Mr. van der Merwe, who was then the new Mako mayor, and I met with DA Councillor Hayward and Andre Roux, who took the minutes of the meeting. Margot Hayward and I reported the fraudulent planning to Johannes van der Merwe, and I voice recorded the meeting. Margot Hayward stated that her and Johan van der Merwe would have to scrutinise the court file, which was then 155700213, which is, this property has a court order on it. Johan van der Merwe informed me that Earth 58 would be a test case. So Margot Hayward said this is the big one, so this is the High Court case, which is costing Chrissy hundreds of thousands of rands. So van der Merwe says, that I believe, and I say, yes, it will probably cost $500,000. Hayward says it's going to be a case study for us so that we can see where do things go wrong. It's very easy to mislead the public and the councillors because we don't have technical knowledge. If someone says to us there's going to be a rider plan, we accept it's a rider plan. Only 2 years later do I, as councillor, find out by a different official who's now in that position, Peter Kukenmer, that there is no such thing as a rider plan. The minute a plan is amended, they have to go back to the neighbours and get new consent. But we didn't know that. We were just told this is a rider plan. Van der Merwe to Margaret, one thing I want to ask you, how long have you been a councillor here now? Since 2007, 7 years, Van der Merwe. And there was nothing at sub-council then. Phillips, nothing. Hayward, never. This case, this application never came to sub-council. Van der Merwe, I suppose there were complaints, so it had to come to sub-council. Hayward, yes, but they justified. The way the officials justified it
why they didn't have to come to sub-council is because of this fraudulent documents where the neighbours were initially asked to consent for certain minor departures, which they gave. Then a different plan is now being submitted with a consent. So they said no, because an item does not have to go to sub-council, even if there's departures, if there is no objections from the Van der Meer. Yes, that's correct. Hayward, yes. So the permission from the neighbours were obtained in a fraudulent way. The plans they submitted that they did not object to were not the same plans that has been built. If you look at the plans that the neighbours have consented to, and you look at what is on the ground there now, it's totally different. So I think, first of all, in this case, an on-site visit would definitely be, one has to go and see at how out of character this house is, and the scale of it, etc. And then also with the plans, maybe with someone who can interpret the plans as well, to show how the plans are different to what's being built. I could not read architectural plans, neither could Mr. Retief, and we were the two most affected parties. After the meeting, Johan van der Meer refused to take my calls or would answer, and instead Andre Roux insisted I went through attorney Ryan Menchie's. Margaret Hayward was refused access to the Earth 58 files by Fiona Ogle and Antoinette Markram, who were the attorneys on the matter. On the 21st of July 2020, I emailed then Mayor Alderman Neilson, you sir, to find out what the status of a 30th of July 2019 DA Heben Rayner, Communication Officer, E-Government for Citizens, EGV4C, Department of the Premier Western Cape Department, investigation, and what relevant department or unit was that could assist me. I copied in the Earth 58 attorney Hofmeyr and Olivia as follows. At point 2, please view this link I uploaded last night. This film also referred to the ground floor roof planter without a west-facing balustrade, and onto which the north and west-facing balustrade subject to this PAAP interview is attached to. At point 3, Mr. Neilson, you are a qualified engineer. I have mentioned you in the video link. This matter can be negotiated easily by sitting in a meeting with my engineer, who is extremely well qualified, not just in engineering, but the legal requirements of construction and health and safety thereof. This meeting would take no longer than 1 hour with his expert reports. 1 hour, Mr. Neilson, instead of spending millions of rands, I put rands, but it's rands, of ratepayer money with attorneys. My point 6 states, it's common cause there have been further applications in 2017 for building work subject to the 15570-213 application, where under oath your official stated the Earth 58 development was built to the 01809-2009 and 01384-2012 approved plans. Clearly, as a contravention notice was served, this simply cannot be the case. On the 23rd of July 2020, 11:18 a.m., Alderman Neilson emailed me a response stating the land use and building plan issues are under the oversight of my colleague Alderman Neerthut. You, madam, you refused to answer my correspondence. I see that her office and that of Cheryl Walters have received email from you. I will leave management of that issue in their hands. Please note that I am not a structural engineer or a geotechnical engineer. My expertise is in water engineering, and I'm not qualified to make any professional judgment on any building or excavation. On the 24th of July 2020, Alderman Neilson emailed me stating, you have chosen the legal route to engage the city. In doing so, it is necessary that you route all your correspondence on this matter via the city's appointed attorney, Ms. Deirdre Oliver. After that, it should be, Alderman Neilson refused to answer or acknowledge my emails. I've complained to the Department of Labour, Premier, Zille, Windy, City Mayors, PBDM officials, the Earth 58 Hofmeyr since occupancy in 2013 that both the north-facing balustrade and the lack of a west-facing balustrade was unlawful, and should someone fall, the Earth 58 owner would not be insured. Furthermore, in breach of the court order, as the property is not built to the 2012 approved plan as testified under oath. All my complaints ignored. I have all the drawings here. I have the engineer drawings. I've requested that the ground floor roof, the upper floor and the roof drawing, engineer drawings be at this meeting. All my complaints were ignored. Contractors are at the property almost daily, and on the 2nd of September 2020, they were loudly discussing many structural problems. I emailed Hofmeyr, that gentleman there, informing him that I'd laid a formal complaint with the city. On the 3rd of September 2020, Hofmeyr emailed me, the work does not require approval from the City of Cape Town, and he therefore sees no need to burden officials who are inundated with matters that do require their attention. I have other emails that specifically refer to the balustrade because Mr. Hofmeyr will say something else. On the 7th of September 2020 at 9:33 a.m, I emailed Alderman Neilson and Earth 58 attorney Carl Hofmeyr, informing them that an Earth 58 contractor was leaning over the planter in breach of the 6-metre setback and MBR, stating my downstairs bedroom intimidating and frightening me. My paragraph 4 stated these planters were non-coloured, built in brick, where under oath Mr. Bradbury and the city stated they were reinforced concrete, which was not only a lie, but these have never been approved. The planters were in any event built in brick because Mr. Bradbury's intention was to remove them. I attached the 2 photographs below. They testified under oath that this brick planter was reinforced concrete, and that's actually in the judgment. It's not brick. He wants to remove it. That's why he's put the balustrade on the outside. I complained about the ground floor roof planters for years having no balustrades on the upper floor patio, as drawn on the 0138412 drawings.
1 minute.
The Earth 50... Sorry?
1 minute.
I've got 1 minute left.
Please.
Sure. Well, you will see if you go to the Evan Solomon's complaint form, that's a fraud. You'll see the one I've just received, AA1. That's one that they said he sent me, which he never did. And then you'll see on page 18 all the email, all the inspections. They all contradict each other. I've got voice recorded the inspections. I know exactly what was said and what was done. It's the same planning officials. The first pane of glass balustrade went up on the 17th of January 2012. On the roof drawing, which I've got here, you'll see that which the satellite is fixed to. You'll see that it's actually written in a fraudulent manner that it was poured on one date, but it actually was poured on the 23rd of August. And Stephen Wilkinson missed the balustrade, the illegal balustrade Alice inspection before occupancy certificate. And then I go through all the photographs, and because Mr. Hofmeyr stated that the photographs, you know, that they're all fraudulent. The Google photographs are all either 2017, 2019. I mean, we're 2024. You know, and my question is, if Mr. Neilson, you had met with me as I begged you in 2020, we wouldn't be here now. This is the same problem. You've wasted millions of rounds of my money and 4 years of my life. I cannot use my property. It's collapsing, sir. I begged you for a meeting.
Okay, but could you please wrap up now? The time
I
is
met
over.
Mayor Plato, who agreed with me there were terrible problems and it should be investigated, and I want to know why it wasn't. And the silly forensics have got a report they were doing in 1718. Everyone ignores me, they won't give it to me. So now I've got to go to court to get it. It's wrong, sir.
Right, thank you very much.
Thank you.
When he was originally approached by the developer's architects and town planner, they really told him nothing about what the property that was going to be developed would look like or be, or the structure or the size. And they gave him documentation without explaining to him what it was, and he essentially signed off an objection form as a blank check. They then developed with no reporting back to him or no asking him if everything was in order according to him. So they put up a property without his consent, having obtained his blanket consent. So where he sits right now today is, and specifically with regard to the property in front of him, Mr. Bradbury's property, is that basically there's huge trees that have destroyed his view, balustrade has destroyed his view, and the house is essentially just a monster in front of him, and his entire view and his scenic drive appreciation has been destroyed. There's an additional problem also of security. He's had a couple of break-ins in his house recently, And workers on Bradbury's property, especially on the balcony where the balustrade is, can see into his property and, you know, taste the area, and that definitely has led to his property being broken into. Now, he's at a stage of his life where he wants to enjoy his last remaining years. He's a man in his 80s, and this property has affected his enjoyment. It's affected the fact that he cannot see as an open view down the road anymore. And the security issue is a huge thing, because we all know in South Africa now, crime is no joke. So these departures that are being asked for, also sort of a kick in the face, because it's very much like the situation in Israel, where you've got in the East Jerusalem and the West Bank properties that have already been built without consent, and now the International Court of Justice says, well, they're unlawful or illegal. It doesn't change the fact that that structure is still there, it will not be removed, and that it affects him. So in a way, today is a farce, because we're coming after the fact something that's already been built. It's not the way to do things. He should have applied for the departure right in the beginning, or when he was intending to put the balustrade up, not after he had put it up, after Phillips had complained endlessly, and then in hindsight, years later, come and ask for the departure. That's not the way it's done. And that's stealth development, which is essentially how he did this entire development from day one. Now, it's clear in your own correspondence that there was a problem with this, because it says here that the second conveyancer certificate states that the proposed development may possibly be in conflict with the personal servitude conditions. So there was a personal servitude between the ratepayers, Mr. Atef and Ms. Phillips, regarding the property, but none of their issues were ever taken into account. And that is happening to this very day. Like I said, this has been built, it's done. There's never going to be an order to remove it, and he's got what he's got in advance without any consent. So that's where we are essentially, and my client just wants to say a few words himself. Des, will you just explain from your point of view, from the beginning until now, what has happened?
Can they hear me?
Yeah.
If you could just switch the microphone on, please. Thank you.
Right. Since this house has been built, my house has been broken into 3 times already. My view is also blocked. I could see it long ago, way back days, the oven rock. I can't see it no more. And I can tell you, the architect, he's not an honest man, nor is the town planner. I've had other things with him, and they say one thing and then say something else. So now, with all this bullying, I've been thinking now of selling my bloody house. Because these people across the road, when they were there, they can see like directly into my place. So now I'm getting a bit hurtful with the whole lot. Right, I think that's the main thing.
I just want to make one last point. Mr. Jody Francis over here was actually an expert and deposed to reports and affidavits in Ms. Phillips's case, where he said that what Mr. Bradbury had built was not lawful. Now he's jumped ship, strangely and ironically, to Mr. Bradbury, and he's saying everything he's done is kosher. I find that a little too much to stomach. Those are our submissions. Thank you very much.
Right, thank you. If we could just have the mic off, please, switched off. Thank you. All right, it's now the opportunity of the applicant to respond. Mr. Hofmeyer, are you going to do all the response?
Thank you, Chair. I believe mainly so, but I have asked Mr. Francis to jump in where necessary. I gathered from what you said at the start that because there were 2 20-minute slots now, I would have 20 minutes. I won't use
two 10-minute slots.
Two 10-minute slots, sorry. I won't use the full 20 minutes, but I will probably exceed the 10 minutes if that's fine. So how I intend to approach it, I've got a bit of a presentation that I'll do just now, but I think I need to just respond to the comments that came in now before I do so. With all due respect, there was nothing really relevant in any of the submissions that were made now. So it's difficult for me to respond there to, and that's why I'll rather focus shortly on my presentation. What I will do is to just make a remark in response to one or two of the observations that were made. Just generally speaking, there's a whole thing being made about historic approvals that were fraudulent, that were unlawful. We've got responses to all of that. This is not what this meeting is about. Courts have decided about those issues, and the courts have already decided that what Mr. Farkel and Ms. Phillips is saying doesn't carry. The courts have upheld the plans in accordance with which the building has been built, and in Annexure K to the record, there's a document by the city's building control department. They did an audit of the building, and they found that the building is in accordance with an approved building plan. Then I really take offense with Ms. Phillips constantly referring to stuff that I have said that's untruthful, and that is untruthful. I have corrected in our response to the appeal the point that she made, and said that I at some stage, she put it up there on the board again today, that I at some stage said that this balustrade doesn't need approval. I'm going to read out of the appeal that Ms. Phillips has seen, where I've corrected the situation, but she constantly refers to that, and I think it's necessary. And I'm just going to read from paragraph 23 of my response to the appeal. I said, whilst it's not relevant in these proceedings, we deem it necessary to highlight one of the untrue, misleading statements Ms. Phillips makes with regard to Mr. Bradbury's or his consultant's attitudes towards the approval and process, in an obvious attempt to discredit them and the approvals granted in Mr. Bradbury's favour. In paragraph 20.4 of the appeal, she quotes from an email that writer sent to Mr. Farkel, in which writer said that certain work did not require the city's approval. She implies that the work that writer was referring to was the installation of the balustrade. Well, that was plainly not the case. Ms. Phillips would know that writer responded to an email from Mr. Farkel in which he complained about certain waterproofing work that was being done on an existing building on our client's property. That was obviously the work that Mr. Hofmeyer was referring to. Untruthful statements like these deserve sanction in the context of an appeal process where they are relied upon to determine binding property rights. I haven't included those emails because it's not relevant in these proceedings. I will present them if it's necessary. I think my general comment as to what happened in the past, buildings that have been approved in the past, responds, I think, almost entirely to what Mr. Farkel and Mr. Retief said, and then just a note on how it came about, how this application came about. At some stage, after receiving email upon email upon email from Ms. Phillips, claiming that there's something unlawful in respect of the building, we instructed an architect to go to the city and say, listen, find out whether this is so or not. I'm not an architect, so I can't say. So we instructed an architect to go to the municipality. The municipality did an audit of the building and said everything is fine, but you need a balustrade here. So my client went, he sought approval for the balustrade, the approval was given and it was built. Only afterwards he was told that we've got this almost enigmatic departure that you need to seek from the scenic drive. And he then brought an application. That's why it was brought belatedly. There's nothing sinister about that.
Mr. Hofmeyer is supposed to be a land lawyer. What is enigmatic about a regulation D1 change in level, the protection of the edge of any balcony, bridge, flat roof of similar place shall be designed to prevent any person from falling?
Chief, I can then move to what is relevant. The scenic drive departure is brought because the features that my client wished to add. Sorry, is this on?
It's on, yes.
Yeah. The features that my client wished to add to his building is said to be in contravention with section 170 item 171.1, sub 1 of the city's development management scheme. I have, unfortunately, I should have given it out previously. I've just made a little bundle of relevant documents that I would like to refer to. I'm sorry, I'm a bit late now. I'll give it to them as well.
This is typical.
Okay.
I do this all the time. It's a waste of time, isn't it? I know, but we've got it recorded for the call.
Chair, so if I can refer to the first document in that bundle, it's an extract from the DMS. It's part 4 of chapter 20 of the DMS, and that's where item 171 comes from. I just want to refer you to the guiding note just below the heading there. That says what the purpose of the scenic drive overlay zoning is. And it says the SDO zoning protects the natural and cultural landscape along the important tourist and transport routes to enhance the scenic experience of travellers and promote the tourism potential of the city. Now, this makes it very clear that the assessment that the city needs to do today in this application relates to an experience of the scenic experience of travellers and the promotion of tourism from a specific perspective or receiving environment. And that perspective or that receiving environment is Victoria Road. Victoria Road is the scenic drive that we're dealing with here, nothing else. And that is what the city is supposed to decide upon. Now, just to assist you with just the spatial orientation of the subject property relative to the appellant's properties and then also to Victoria Road, I've included as the image 1, I've included an aerial photograph of the properties. Now, I must just start by saying there was a miscommunication in my office that I take full responsibility for, where the one property is shown at the wrong place. We've made a little arrow there to indicate that it's wrong. I'll just take you through that picture now. You'll see Victoria Road is a road in green that runs from north to south. The red property there is the subject property that abuts the scenic drive. The yellow property to the west of my client's property is Ms. Phillips' property. So my client's property is between her property and the scenic drive. And then contrary to what is shown in that picture, Mr. Retief's property is across the road from my client's property. So it's across the road on the other side of Victoria Road. So that is how they orient with respect to Victoria Road. Now, as I said, the assessment that the city needs to do needs to be done from a particular perspective, of a specific point of view, and that point of view is Victoria Road. And to assist with our orientation of that perspective today, I've included 3 images that show Victoria Road and the subject property relevant to Victoria Road. Image 2 shows it is a view down Victoria Road in a northeasterly direction. And what is relevant there is that you won't see the satellite dish on top of the roof. You won't see the balustrade. And you won't see the balustrade because the balustrade is right on the other side of the building. It is on the western side of the building. Am I right now with my western? Let me just make sure. Yes, it's on the western side of the building, not on the scenic route. Right in the middle of the building, just above the little wall on my client's property, the wind lobby, that's not really an issue here today, but that we do apply for will be visible. It'll be a glass wind lobby that protects the front door against wind. Image 3 shows a view down Victoria Road in a southwesterly direction. You'll see there's the satellite dish is visible on top of the building. You'll see there's a green hedge there. The balustrade, not the balustrade, the wind lobby wouldn't be visible because the wind lobby would be behind that. The balustrade that's an issue today you can't see because it faces west. The balustrade that you see there now on this picture isn't relevant. That's a north-facing balustrade. That's a pre-existing balustrade. Image 4 is a view from immediately behind my client's property, right in Victoria Road, looking towards my client's property. Ms. Phillips' property is now behind my client's house, and Mr. Retief's property is behind the viewer. Now, you'll see there to the left of that photograph, there's a glass front door. That's the front door around which a wind lobby will be constructed, or ought to be constructed just for protection against the wind. You can't see the satellite dish, and you can't again see the balustrade because the balustrade is on the other side of the building. In other words, the opposite from where the scenic drive is. Now, I emphasize that this is the perspective that the city should take. We must look at it from Victoria Road. But let's assume that Ms. Phillips were right, and it were incumbent on the city to also look at it from her perspective, which I feel is wrong. But let's assume that for the moment. The city has done that. They have considered the glare of the balustrade as per Ms. Phillips' complaints, and their response, the MPT's response, was to approve nevertheless, and the reasons for the approval was summarized, I think, on page 11 of the record, which I have reproduced in the bundle. It is, I think, the 5th page, just after image 4. And I'm just going to read the relevant part to you. You can read the whole, obviously you need to read the whole part, but let me just read this to you. So the MPT said, however, the objector's concerns are outweighed by the factors in favour of approval. Namely, the balustrade is a necessary safety measure. Glass balustrades are a common architectural feature in the area. Glare from reflected sunlight is not uncommon in an urban environment, and neighbours have a duty to be reasonably tolerant. Solar glare occurs for only part of the day. The applicant has sought to reduce the reflection by using a matte finish on the glass balustrade, and the objector can take further measures to reduce the effect of the glare. I need say no more. The MPTs considered it, and I believe come up with very good reasons to approve the balustrade nevertheless. And Chair, just to illustrate the pervasiveness of glass balustrades in that area, I've included image 5 and image 6 to start with. And I've numbered, and I said there more or less where these buildings are relative to the subject property. Image 5, I said, is a view of a house on the opposite side of Victoria Road, approximately 120 metres from the subject property, and I've numbered the glass balustrades on 3 levels. Image 6 is a view of a house on the opposite side of Victoria Road, approximately 20 metres from the subject property, and you see that the glass balustrades on both levels. And then image 7 is something that is in the record, if I'm not mistaken already, but this is just to give you an understanding of glass balustrades viewed from Ms. Phillips' property already. This is a picture that Ms. Phillips or someone on her behalf at some stage took. In the foreground, you can see the balustrade that's an issue now. You'll see it's got a matte finish. The reason for the matte finish is is because Mr. Bradbury tried his utmost to take away any conceivable glare. And you'll see there to the left, there are 2 buildings in the same view corridor with glass balustrades on 3 levels. They don't have a matte finish. They face exactly the same direction, so the glare should be much the same. Then, I think, she didn't touch on it now, but I think it's necessary to just point out the following out as well. Ms. Phillips makes something about the fact that, or the allegation that certain parts of the building haven't been approved, and balustraders are now top of that, and because of that you can't approve the balustrade, the departure for the balustrade. But there are many counters to that. The first thing is that there's no requirement that a building plan must be approved for something before you can grant a departure. There's no such requirement. Secondly, as I've already said, the city's building control department has confirmed after doing an audit that the structure is in its entirety in accordance with approved building plans. And then lastly, the balustrade itself has been approved. Chair, if I can then just move to the issue of the satellite dish and the height departures. I have reproduced on the, I think it's the fourth last, the third last page in that little bundle. I've reproduced item 190 of the DMS. The item in issue here is 195B, which says that no point on any structure shall be higher than 6 meters above the existing ground level immediately below such point. Now, just as a general comment, it's debatable, and I'm not going to take it further, but I just mention it. It's debatable whether we needed to bring this application at all. Because, firstly, it's questionable whether a satellite dish fixed on top of the roof can be said to be a structure or a point on any structure to which this provision applies. And secondly, this satellite dish doesn't sit on the edge of the roof, it sits on top of the roof. So there's no existing ground level immediately below that. There's a roof below that. So I mean, I question whether or not this departure was necessary at all. But let's, for present purposes, don't split there and accept that we've brought that application. The application was approved by the MPT, and it's been appealed, and that's why we're now here. Now, if you go through the appeals and the grounds of appeal, you won't find any substantive objection that they have with the satellite dish. And the reason being, there's satellite dishes all over. The satellite dish, if I'm not mistaken, she can correct me if I'm wrong, isn't even visible from Ms. Phillips' house. The issue that they raise is that the satellite dish is in conflict with a servitude that's registered over Mr. Bradbury's property. Both we and the city have pointed out in our response to the appeal that the city is at liberty in terms of section, I think it's 49, capital A of the MPBL, to in certain circumstances approve a departure that is inconsistent with a servitude, as long as the servitude wasn't imposed in terms of land use planning ordinance or the township ordinance of late. And the city was aware of that. They considered the interest that the servitude sought to protect, and decided nevertheless that it can be approved. I want to get to the reasoning for that approval just now. But before I do so, I think it's just necessary to mention that this is not the first position on my client's property where this satellite dish sits. It used to be against his garage. Ms. Phillips then complained about it being there. My client then said, at great cost to him, we moved it to another spot. Another neighbour then said, listen, I can't see Lion's Head from where it is now. And my client then decided, well, on advice from these people that advise you about satellite dishes, I don't know what you call them, but there's only one place left where you can put the satellite dish, and that's on top of the roof. So he's put it on top of the roof where it bothers no one. It should bother no one. The city has considered the issue of the servitude. 1 minute. And I've reproduced their reasoning, I think on, I'll see now, but I'll just read their reasoning quickly. It says the satellite dish does not significantly adversely impact on views and amenities of the scenic drive, given that A, the satellite dish is relatively small, B, the aesthetic and scenic quality of this section of scenic drive was irredeemably compromised years ago by buildings which project above this section of the scenic drive and block views of the ocean for vehicles driving along the road, and C, the visual impacts are mitigated by background buildings which create complex urban background. And then just, I'll conclude, the last few images or annexes to this bundle of mine are photographs, street view photographs of other satellite dishes in Victoria, grow in close vicinity. And you can also look, I think it's on pages 182 to 183 of the agenda item, where there are a number of pictures of satellite dishes in that area. Thank you, Chair.
Okay, thank you very much. I'll give the appellant an opportunity to respond to Mr. Hoffmeyer's comments.
I totally disagree with him. He hasn't built these approved plans, and I'd like to know who the city officials are. Is it BCO Maris Lawrence? Is it Greg September? Is it Juliet Leslie? Is it Evan Solomons? Who? I mean, I've got the names of the people on the that did the. It's all on my thing anyway. And I complained about the satellite dish in 2013. The reason Mr. Bradbury moved it was because it destroyed my trees. It blew off and destroyed part of my property. And furthermore, what I want to say is that he forgets there's a court order. And okay, Honourable Judge Bozlak said the agreement is firmly in place. So the predial servitude is firmly in place. And if the city want to ignore a court order and they want to ignore the SACAP finding the architect guilty of fraud, then, so be it. There's nothing I can do about that. And I will show you, Jodie Francis was involved with this. If you go to my page 69, Jodie Francis's own land surveyor, Mark Jenkins, who was my surveyor, and Jodie Francis wrote reports in the court application that Honourable Judge Bozlak gave a judgment saying that Mr. Bradbury's house wasn't built to the 2012 plans, and I note for record that he's now saying it is. It isn't built to the 2012 plans, so I can prove that beyond reasonable doubt. I requested reasonably that Mr. Bradbury or Mr. Hoffmeyer brought the ground floor roof, upper floor and roof drawings to this meeting. I've got the drawings here. They have already been confirmed as a fraud by the public protector. These drawings have fraudulent notations on them. They're not, I sat with Mr. Hoffmeyer and he can say what he wants about me, but I speak the truth. I sat with Mr. Hoffmeyer in a meeting with Ozzy Gonzalez and he explained exactly what was going to be approved, i.e. coloured, from the 2009 drawings. You can see the colour, there's hardly anything. All the application form says is a wall moving out. It says that there's a swimming pool and there is a garage. Now the swimming pool's supposed to be in ground. Now if you look, and the height departure we had was for a tiny little basement garden for illumination. I can take you through it. And now I discover, a year and a half ago, that the plans that all of these drawings rely on are only sketch plans. There are no 2009 approved plans. And like I said, if you go to page 69, you'll see that the planter has actually been put behind the pole that was there, okay? And they've actually now built the planter onto an extended roof, a ground floor roof. Now, the judgment clearly states that cannot be used to walk onto, he cannot walk over the planter. He cannot maintain the planter. And I don't need to tell you about Section 7 of the National Building Regulations. It's derogation of value to my property. Now, the city municipal valuer came to my property in August 2019. I only now discover he's a City of Cape Town plans examiner. We discussed at great length with the Valuation Appeal Board, about this planter. Why did he not investigate as he was told to? He was a plans examiner.
if you look at the gas installation, which you'll notice that Evan Solomons hasn't mentioned in his complaint form, you'll see that he'd already put the glass balustrade on the ground floor roof. It wasn't lawful when Judge Boslak visited the site inspection. Now, if the city want to go ahead and do this and approve it, I can't stop you. But I will tell you that anyone who can see and watch these contractors, because now they have to clean the windows all the time, they're standing on a planter which is it's in breach of the D1 regulations. It's, you know, you stand on the planter and the balustrade is here up to their knee. They're going to kill themselves if they fall over. If you look at all my photographs, you'll see them stepping over and they're walking on a concrete awning that has no plan approval. It was demolished in November 2012. What did they do? They rebuilt it. You know, it's not even coloured on the drawings. You know, Stephen Wilkinson has drawn fraudulent, he calls it Loffelstein, but actually it isn't. It's a terraforce which we had no idea had approval until, you know, only was it when Mr. Hofmeister sent the ground floor layout drawings and a section of terraforce, which is a joke, you know. And the fact is, Gregory September himself says, you know, in the correspondence at that time when the departure was being approved, you know, the fact is the height departure is for a small cutaway of ground. Now, he's laid a whole concrete floor that he told Inspector Zeeby from the Department of Labour was a ground floor. This is when they had a cease works order. Well, I don't even know, at that time I couldn't read plans. Now I've educated myself and I could read plans. But I didn't know at that time. I just thought a ground floor is where the road was. Nobody told me ground level's going to be raised over 2 metres. And if you look at the sketch plans, the garage hasn't got any retaining walls. It's not possible to raise ground levels that high. The swimming pool sits on a building with retaining walls, not on the approved drawings, but on the engineer drawings. And if you look at the engineer drawings, which I'll happily take anybody through, if you sit with me, I've got a whole 300-page forensics report on this. That's all I've ever asked for, is someone to sit with me with a forensic report. And if you prove me wrong, I will go quietly. You know, I don't, this wasn't my gig here to end up like this. But I cannot be bullied when I know that I am in the right and I've done everything I can. It's all very well saying, oh, you know, why don't you launch an application and set the departures aside? Why? It's not built to an approved plan. There's no 2009 plan. There's sketch plans. There's no roof drawing on which the black and white drawing, the 104 drawing in the 2012 plans, is black and white. There's no colour. It says the roof was poured on a certain day. It wasn't. I've got the pictures. So what I've done is if anybody's ever interested in sitting with me, and I'll do it happily, I've got it from the beginning of demolition right to the end. I've got all the engineer drawings. I've voice recorded every single PIA viewing I've been to. I've got, you'll see at the beginning here, I've got all the city building inspector inspections. Why did they miss a simple balustrade? Why did they miss a simple D1 balustrade contravention? That's why nothing they say can be relied upon. And I apologise. And I have to say, Gregory September, when I've gone through the record, was actually right in 2009. It wasn't him. It wasn't Juliet Leslie. It was Ozzy Gonzalez. He overrode. And he's got to answer. And I'm tired of officials hiding behind attorneys and refusing to answer me. You know, it wasn't right, with the greatest respect, that you both chose to say I was in litigation. This had nothing to do with the litigation. It had to do with, you know, Margaret Hayward tried her best. And, you know, at the end of the day, we're going, you know, as you know, we're in court, and they will be subpoenaed. And if this gets approved, I will tell you now, I am going to court. because this cannot be allowed to go on. You cannot allow somebody to breach a court order. Someone in their special plea in the damages claim has just said, no, we didn't have any demolition permits. No, we didn't have any geotechnicals, a structural geotechnical engineer. They didn't have a geotechnical engineer. I've only got bending schedules for one section that involves Tony Stern's property, not mine.
Phillips, could you wrap up, please?
Oh, sorry. But I'm just trying to, because nobody will sit with me to go through this. Nobody will sit with me to go through my forensic report. The structural engineer has only signed it with a. He hasn't even signed anything. He's just crossed off structural. No demolition permits, nothing. And the city refused to give me access to records because I was in a court process. It was wrong. And I can't allow people not as lucky as me to have the strength and have their property rights taken away, because by asking for departures, he's asking for departures that affect my property rights. I can't use the front of my house. I haven't done. I can't use it. I've got plenty of video of the glare. I've got plenty of people who will give affidavits about it. It's bad.
Okay.
And
please conclude now.
Oh, sorry. Yes, I've concluded.
Mr. Farkle, did you want to respond?
No, I stand by my original submissions as regards Mr. Tiff.
Any further from you, sir?
I think nothing. Thank you.
Okay, thank you very much then. That brings the interview to a close.
Is Jodie Francis not speaking?
Sorry. No, well, they used their
You're
full
not speaking.
time.
Oh,
Except I
Jodie.
must perhaps just give, is the panel in any way have any questions of clarity from either party? We're not. We're satisfied we have all the information. All right, thank you very much. So therefore I will conclude the interview and we can excuse the parties now.
Thank you.
Very much.
Sir, just before we go, would it be possible for me to sit and meet with a city official and a city engineer, that I could just go through all
let
of
me
this?
just make it clear, that's outside the remit of
I
this
understand,
bit.
but I'm
So-
just putting...
So,
There are some city
whether there
officials
is, you will have to approach,
I've tried to, sir.
you'd have to approach the male committee member concerned. That would be the correct...
They won't talk to me because they say I'm a litigator.
Okay, well, I'm just saying is that I cannot, from this seat, be involved in any of that. We are purely dealing here with the land use application, whether that's approved or not. That's the only matter in front of us.
And if you could, just when you go through my things, if you could just look at the actual photographs and not those Google photographs should never be allowed in any record.
Well, we will make our own assessment.
Thank you, but they really do not. They're not the real.
Okay.
The
Thank
real
you.
view.
So the parties are excused, please.
Thank you, sir. Thank you, everybody.